All right. Well, so welcome everyone. Uh, we're incredibly excited to welcome everyone to the first of many Harvard College public debates. I'm Ishan, and co-moderating with me is Mish. We're the founders of this initiative with the HCDU with the goal of bringing lively and topical debates between experts and public figures into the public square. We're extremely grateful to be joined for this inaugural debate by Professors Mark Tushnet and Todd Henderson.
As you can see on the poll, the motion to which our debaters will be speaking today is this House supports significant radical reform of the Supreme Court. While we properly introduce our guests, we'll be sending out a poll, which you can now see, asking whether before hearing both sides' arguments, you support significant radical reform to the Supreme Court. We will also be asking you this question after the debate, as well as a question about whom you thought won the debate. That is, you might vote that a single side won the debate without necessarily changing your opinion about the debate.
Speaking on the affirmative side of the motion, we have Professor Tushnet. Professor Tushnet is the William Nelson Cromwell Professor of Law at Harvard Law School. After graduating from Yale Law School, Professor Tushnet clerked for Justice Thurgood Marshall. Professor Tushnet has made remarkable contributions to the field of constitutional law and theory. He has written extensively about judicial review, constitutional history, and civil rights law. We're excited to have him open the debate for us today. Accompanying Professor Tushnet is the Harvard College Debating Union's own Vivian Zhang. Vivian is a sophomore at the college studying applied math and economics. Who better to speak about the US Supreme Court reform than a friendly neighbor from Canada?
On the negative side, we have Professor Henderson, the Michael J. Marks Professor of Law at the University of Chicago Law School. After graduating from Princeton Law, Professor Henderson clerked to the Honorary Dennis Jacobs of the US Court of Appeals for the Second Circuit. Professor Henderson's research focuses on corporations, securities legislation, and economics. He has also written widely and notably about banking regulation, torts, and constitutional law. Much to our delight, we discovered he's also a fiction author of the legal thriller Mental State. Accompanying Professor Henderson...
And the sequel is coming soon. The sequel's
coming soon. There you go. It's Hub Live.
That's right.
Accompanying Professor Henderson on the negative team is the HCDU's own Asher Spector. Asher is a senior studying statistics and mathematics, and having worked for Facebook last summer, we think Asher brings a unique perspective on constitutional liberties and shaping the future of the country. The format of this debate will have opening statements by our experts, rebuttal speeches by our HCDU debaters, after which we'll open the floor for audience questions, which you can message over chat to Ishan or me. We'd encourage you to message us questions throughout the debate, as I mentioned earlier. Finally, we'll close the final speeches from our experts in inverse order. That is, the negative will speak their reply speech at the end, followed by the affirmative side.
And in a couple seconds, we'll be closing the initial poll about your prior opinion on the on this topic. So if you'd like to get in your answer really quickly, if you haven't yet, we'd appreciate it.
I think that concludes our pre-polling. Without further ado, we'd love to open the floor to welcome Professor Tushnet to open the debate.
Hear, hear.
Thank you. I appreciate the opportunity to discuss and debate this important topic. I'm going to start with some facts to provide the context for the current discussion. So since 1968, that is for going back more than 50 years to the present, we've had Democratic presidents in office for 20 years, Republicans for 32 years. So Republicans have been president for 61% of the time. During that same period, 13 justices have been nominated by Republican presidents and 4 by Democrats. So Republican nominees 76% of the time. Now, the difference between 76 and 61% might not seem that large, but partly that's an artifact of the fact that the presidential terms are lumpy. That is, they come in 4-year units, whereas the judicial timeline is more or less continuous. And one way to see the significance of this, these numbers, is that during that entire period, that is from 1968 to the present, more than 50 years, there has not been a single year in which a majority of the Supreme Court has consisted of justices nominated by Democratic presidents. That is, there's been a majority of justices nominated by Republican presidents for now more than 50 years. And just to, I don't know, cap it off, although the significance of this is also a little tricky, the last time we had a Chief Justice who had been nominated by a Democratic president was in 1953. That is almost 70 years ago, 65 years ago. Now, why does that matter? Well, the reason that it matters is that, as we all know, we have a system in the United States of separated powers where each institution, each branch, is a participant in a system of checks and balances. So, for example, and we ordinarily think of it in this way, Congress can check an overly aggressive president, or a president, by vetoing legislation, can check Congress. And significantly for the current discussion, we ordinarily think of the Supreme Court as an important mechanism for checking both Congress and the president. But that's an incomplete picture because everybody's supposed to be part of the system of checks and balances. And so there should be and are mechanisms for checking and balancing the Supreme Court. And there's nothing illegitimate about that. That's the way the system's designed. Now, as the system has worked out, the primary mechanism for doing the checking and balancing for the Supreme Court has been the system of nominations and appointments. And that's why my opening recitation of facts mattered. Through periodic appointments and nominations and appointments, political actors representing the people who elect them express their approval or disapproval of the general course the court has pursued. That is, nobody thinks that nominations and confirmations occur with respect to particular decisions, with minor exceptions, but the mechanism is to operate sort of across the board. How overall do you think the court has been doing? And in particular, do you, the people's representatives, think that there ought to be some tinkering, tweaking with the course that the court has been following? Now, that mechanism of checking and balancing by means of nominations and confirmations worked well for quite a while, even though replacements to the court occurred at essentially random intervals, while changes in the political branches occurred more regularly. And the reason for that is based on what I'll call the pace of political time versus the pace of judicial time. The pace of political time is determined by the election cycle. So 2 years for members of the House, 4 years for presidents, 6 years for members of the Senate. The pace of judicial time for these purposes is set by the rate of replacement when vacancies occur so that they can be filled through the mechanism of nomination and confirmation. Now, with that distinction or that idea of judicial and political time in hand, what we can say is that historically, the pace of political time and judicial time in the past wasn't all that different. They weren't exactly the same, of course, because political time occurs on these regular intervals, whereas replacements occur irregularly. There were never pre-identified periods when a judicial vacancy would occur, but for reasons that probably we could go into, the difference between the pace of political time and the pace of judicial time wasn't that different. But as the numbers that I provided indicate, something has changed. And what's changed is happened in connection differently, but both to political time and judicial time. So in particular, political time has accelerated, sped up. We have permanent campaigns. Essentially, a week after a member of the House of Representatives is sworn in, he or she is actually now required by the House leadership to start making phone calls to raise money for the election 2 years away. And in addition to the permanent campaign, or maybe a collateral aspect of it, politicians are permanently concerned about remaining in or losing office. That's why they campaign constantly. And one reason that they are concerned about, in particular, losing office is that they are worried about losing influence on policy. Now, one way to perpetuate policy is to put judges in place who will do what you think is good policy even after you're gone. There's some well-known accounts of the justifications, the political justifications for judicial review, known as the insurance theory of judicial review, that take the appointment process as a mechanism for ensuring the perpetuation of the policy positions of people who are no longer in office. So with the acceleration of political time, politicians pay much closer attention to perpetuating on the court the views they hold. What's happened to judicial time? Well, as political time has accelerated, judicial time has slowed down. And the reason for that operates sort of both at the back end, which is easier to explain, and at the front end. So at the back end, people, judges, just live much longer than they used to. I don't want to go into statistics, and they get messy about life expectancies, but judges overall have been remaining on the court for longer periods than they had historically, in part because historically judges departed for reasons of ill health or death, and that's just taking longer to happen. At the front end, politicians, because of the things that I've already mentioned, have grasped the idea that appointing people at a younger age gives them a longer period of influence over the future. And so the age of appointment has gradually drifted downwards. If you look at the ages of appointment, there are scattered examples of very young people appointed historically in the past, but overall, the age at appointment has shifted downwards some. When you combine the front end effects of younger appointments with the back end effects of better healthcare, you get longer periods of time on the court. And with the acceleration of political time, that means that the chance of a disjuncture between the political system and the judicial system increases. And that's what we've experienced. And so, just to get to the proposition, the system of checking and balancing by means of an irregularly spaced appointment process no longer works the way that it did. And in order to sustain the system of checking and balancing, something needs to be done that will respond to the problems created by the disjuncture between political time and judicial time. Exactly what needs to be done is up to politicians and people to decide, but because the system as designed doesn't work the way it did work for quite a while, it seems to me that what the question before the House poses of radical reform of the court, that seems to me appropriate, again, to preserve the overall system of checks and balances.
We thank Professor Tushnet for those remarks and for an excellent opening to the debate. We'd like to invite Professor Henderson to open the case for the opposition. Hear, hear.
Thank you. So I want to make 7 points. Hopefully I'll remember them all in a short amount of time. The first one is probably the most important, and that is that the goal for this should be to model how people who disagree can get along and respect. I certainly am honored to be here. Professor Tushnet has forgotten more constitutional law than I'll ever know. So it's great to share the forum with him. And I hope, in an era where people don't get along very well in policy debates, I hope we can set a good tone for that. Okay, so my second point is I want to stick to the title of the resolution, which is radical reform. That's the key word in there. I'm against radical reform. We could talk about minor reforms. Radical reforms is a terrible idea. I'm a conservative. I'll put my cards on the table. And what it means to be a conservative is not, federalism or a position on abortion or anything like that. What it means is to be, respectful and trust that the history that has gotten us to where we are is valuable. And we don't know all the reasons why the system we have works the way it does. So, I look in history and I say, when has radical reform ever worked? The French Revolution, when they tried to, change the calendar system and completely upset the society, various communist revolutions that were all about radical reform. I can be in favor of evolutionary change and incremental change, thoughtful change. I'm against radical reform. And I think the burden given this long history is a heavy burden for them. The court seems to be working pretty well. I'll talk about a little bit more of that in a second. So this is just sort of an Edmund Burke point. The wisdom of long experience should not be rejected based on current human plans. Professor Tushnet talked about leaving it up to the politicians. That scares me. I look at who our politicians are, from Trump all the way down to Alexandria Ocasio-Cortez, and I don't trust them to fiddle with our court. Okay, point 3, which is related and about the Supreme Court working pretty well. So first of all, most cases are 9-0. And, the court has an incredible amount of unanimity. With respect to the close cases, and I know that's what garners the headlines, with respect to those close cases, and, you think of the socially contentious issues the court has had to address just in our lifetimes. I want to cite to Professor Tushnet's colleague, Maya Sen, who teaches at the Kennedy School at Harvard. Her work appeared, my recollection is in the beginning of July of 2020, above the fold in the New York Times. And, paraphrasing, she said, our studies showed the court's opinion in every major case was exactly in line with public opinion. They did one of these great New York Times graphics where they showed public polling on issues and how the court decided them. And there was perfect alignment. This is a 5-4 at the time, a majority appointed by Republicans. Republicans Professor Tushnet is correct. Republicans, by just happenstance, and also that they generally care more about judicial appointments, have dominated the court for decades. But on social matters, at least, liberal policies have prevailed because the justices who are on the margin, the marginal justice, has been attuned. They've had their antenna up for what the public demands, and they don't want to get too out of step with that. Abortion, gay marriage, flag burning. We could go on and on things that have come out in the quote unquote liberal perspective. Just this year, with a Republican majority, the court repeatedly ruled against the president, requiring disclosure of documents in litigation with the New York state, against his repeal of DACA, against his desire to bring in some xenophobia to the census. The court ruled in favor of Indian tribes, giving them half of Oklahoma, in favor of abortion rights, in giving LGBTQ people discrimination rights in employment in a statute that was passed in the 1970s, which clearly never intended such a thing, in favor of criminal defendants in cases about juries. I could go on and on. So I'm not so sure why Democrats, and it's been Democrats who've been pushing this, or liberals, why they're so upset. It seems like they're getting what they want in the Supreme Court. And I think Professor Sen's research suggests that will continue to be the case because the court is not stupid. The Chief Justice wants the court to maintain its legitimacy, and that means being political. And that doesn't mean political, Trump appointed me and therefore I must do this thing, but reading what the political tea leaves are. Okay, point 4. I think most radical reforms of the court would be unconstitutional. Certainly the ones that have been talked about in the press, that you heard members of Congress and even the president-elect talk about, court packing, term limits. Look, the Constitution was designed and the founders built the Supreme Court to be independent of the political branches, to provide a check on the political branches. They were obsessed, the founders, in our Constitution with things to make sure the independence of the courts was sacrosanct, life tenure. In fact, you can't even lower Supreme Court justices' salaries. That's how concerned they were with the politicians fiddling with the courts. You can't change their salaries. And yet people are saying, well, we can pack the court for blatantly political purposes. Professor Tushnet started with R's appointed this many judges and D's appointed this many judges. So Democrats are upset, disappointed, frustrated that the political system and the quirks of who retired when and so forth have made it so they have fewer Supreme Court justices. I don't blame them. This debate is not about whether Merrick Garland was treated fairly or not. Personally, I don't think he was. But my personal views are kind of irrelevant to the question of whether or not we should radically remake the Supreme Court to solve that particular problem. Intent matters in constitutional law. There are things you can do with good intent that you cannot do with bad intent. Again, President Trump's, a lot of the cases in which he lost was based on his motive for overturning an agency's rule or the like. So in our history, Congress has increased the size of the Supreme Court, for example, but it did so because the court had a large workload in the 18th century and early 19th century. And justices had to ride around in carriages to sit in rural parts of the United States. And that's just not the case anymore. So politically changing the court would risk really undermining it. And that leads me to my 5th point, which is this risk of politicization. Independence is a key function of the court. The other one is to be counter-majoritarian. The court is a counter-majoritarian bulwark of individual rights. Majority rule is essential in any political system. It can be oppressive. So you need courts to check the majority. Sometimes the majority wants to oppress African Americans or gay people. And sometimes it wants to oppress religious people or people who have property. The court is there to stop them, to make sure individual autonomy and rights are respected. If politicians fiddle with the court to make it more political, Democrats say, who are in power now, and assuming they win the Senate, and they fiddle with the Supreme Court to make it more in line with a majority, to address the concern that Professor Tushnet mentioned between judicial time and political time, then it loses its counter-majoritarian function. It's just a mechanism of the majority. That's not the way the Supreme Court has been designed. And people like Professor Tushnet's former boss, Thurgood Marshall, they were champions of this kind of counter-majoritarian spirit. Point 6, all reforms will lead to tit for tat. And that kind of getting into political tit for tat, you did this, we're going to do this, and so forth, will risk completely undermining the Supreme Court. Packing, as an example, obviously does this. If the Democrats add a bunch of justices, Republicans, when they're in control, they'll just do the same thing. But this problem is also true for other plans, seemingly benign plans like 18-year term limits. These have a lot of variables. What about premature deaths or retirements? What about the problem when the branches have different political alignments, like the Garland problem? How do we get from here to there, the transition? How does the Chief Justice get picked? Work by my colleague Adam Chilton and Maya Senegan shows that very small differences in design of all these various plans that are out there, and there are 7 or 8 of them, lead to very large, and they show unexpected differences in the composition of the court over time. And so this is a really, our plans, what we think is going to work, may quickly unravel, and there's going to be winners and losers eventually, and then there's going to be potential for other reforms, and this can lead to just a tit for tat cycle that I think we should want to avoid. Okay, I'm almost out of time, so let me just end quickly with point 7, and another reason why you should oppose this. It's not going to happen, and so you should be against it. Democrats do not have the votes. Even if they win the 2 special elections in Georgia, Senator Manchin from West Virginia has come out and said he's opposed to this, so they're not going to happen now. Roosevelt couldn't do it at the height of the New Deal. The Senate report on the subject eviscerated Roosevelt, and he backed down. The votes in this election, especially the popular votes in the House, if you sum them all up, shows the country is incredibly divided. And a radical reform of the Supreme Court would risk tilting that public against Democrats. If I was a Democrat, was for their policies, I would stay far away from the Supreme Court. I would use my legislative majorities and the president to get legislation passed. Even Amy Coney Barrett in her nomination hearing said, my job is, I'm not here to strike down duly passed statutes by the Congress. And I think Democrats should focus their efforts there to get the policies they want enacted and leave the Supreme Court alone. Thank you.
We thank Professor Henderson for fine opening remarks for the case for the opposition and invite Vivian Zhang to continue the case for the proposition side. Hear, hear.
Yeah, thank you, everyone. First of all, shout out to my blockmate Matei, who came up with the best ever Canadian Supreme Court punchline. I'm going to get started. You know what's sweeter than maple syrup? A functional Supreme Court. So we think that shifting trends in the American system makes significant reform necessary because they're increasingly polarized politicians. They're slowing down the judicial system to maintain their choke on power for longer than ever before. And over the last 4 years, we've seen an administration sacrifice quality for influence by selecting Amy Coney Barrett. And we've seen a lame duck president who is willing to violate unwritten norms for appointing justices by nominating at the end of his term. A Supreme Court that can be manipulated in this way isn't serving its purpose. It's very political and leaning towards one side. It's very skewed. And the change of political and judicial time, as Professor Tushnet talked about, makes it necessary to introduce significant reforms to the Supreme Court. So Professor Henderson talked about how radical reform, he doesn't like the word radical, and this is something that we should talk about. But I don't think the focus on that buzzword is as important as talking about the concrete terms of what we're talking about. So a lot of the times what conservatives think of as radical is court expansion, term limits, which I'm going to explain why those are perfectly reasonable things that we can support. And the focus on that word shouldn't necessarily deter the focus on the rest of the debate. On this idea of consequences of accelerating political time. So Professor Henderson argues that this makes the court more vulnerable to the swing of politics, and we don't want it to be too political. But the problem is, their side needs to prove that the political back and forth is actually worse than what we've already seen over the last 4 years, and will likely continue to see, because we both acknowledge on both sides of this debate that we have a very divided version of America. So if we don't reform, what is the counterfactual that Professor Henderson and Asher have to support? It's a counterfactual where it's a Supreme Court that benefits one side more than the other because it's not responsive to the swing of politics. We've seen that one side of the political divide seems to be more tame than the other side when it comes to following traditionally unwritten rules to get the political outcomes that they desire. And so they say that it's not about, like, for instance, whether Garland was treated fairly, but it very much is, because as they acknowledged, a lot of cases that are very important, like on voting rights, are decided on very narrow margins. So Mitch McConnell is able to declare Garland's nomination void by claiming that the appointments were so close to the next election that the incoming president-elect should be the one deciding. He was able to do this because he didn't think that Democrats were the type of party to be not tame given their voter beliefs and voter base. And yet a Republican lame duck president at the end of his term was able to go against this tradition and appoint ACB, who is a young justice. We think that it's necessary to have some degree of institutional reforms to restore some sort of even grounds. But also another problem that when one side secures the court is that they use it to their political advantage. So for instance, when conservatives figure out that something will not pass through the legislature, they often throw lawsuits at the court, hoping that some iteration will stick. And Justice Kavanaugh actually compared this process to playing a game of whack-a-mole. If it doesn't work, they try another lawsuit, and they try another lawsuit. And this happened in the case of, for instance, Obamacare, where people were throwing rocks against the wall in the court to take it down when it became clear that the legislature wasn't a viable avenue to repeal it. It also happened with the Voting Rights Act, where opponents couldn't repeal it in Congress, so they were like, you know what, we will file lawsuits against it, hoping that one of those will stick. And so at the end of the day, we get a lot of dozens of lawsuits in bad faith, trying to target a single policy from different angles. And if we end up with a court that becomes a vessel of these sort of minoritarian ideas that goes against what we fundamentally believe that the court should do, and we're left with not just a slow court with young, underqualified appointees who are going to be there for a very long time, as Professor Tushnet talked about, because they have longer lifespans, they're going to have a lot of influence for a very long period of time. It's a court that services people on one side of the political divide consistently more than the other. And over the last 4 years, we've seen multiple violations by a single political party. The other thing is they talk about how all reforms will lead to tit for tat, and they especially cite this instance of court expansion. But we think what's more likely to happen isn't the traditional tit for tat strategy, but rather what political scientist Robert Axelrod from the University of Michigan calls tit for tat with forgiveness. What does that mean? Well, Professor Axelrod invented a game of iterated prisoner's dilemma, which is basically a prisoner's dilemma repeated over and over again with the same opponent. And it's a good model for court expansion because politicians from the two major political parties in the United States rotate, and there's a trend where they take turns. And he found that if you kept doing selfish strategies like tit for tat, that tended to be unstrategic and lead to worse outcomes for yourself in the long run. And especially because Professor Tushnet explained how politics and campaigns, they're becoming more permanent. The moment a politician gets elected, they're thinking about when they're going to get elected again. Party-wide, the party is an important institution that's there to stay for the long term. They're career politicians who are there to stay for the long term, care about long-term impact. So they're more likely to engage in a forgiving tit for tat strategy where sometimes they do cooperate even if the opponent did not, and that actually prevents escalation in all cases. So we would very much counter this idea that there would be escalation in all cases of reform. So at the end of the day, we don't think it's necessary to focus as much on this word radical. What's more important is to recognize that the counterfactual of what the court looks like, the court that they actually have to defend, is one that is extremely politicized and that is targeted towards one side, skewed towards one side of the political divide. That's not what we want in an already polarized America. And that's why Professor Tushnet and I are on this side. Thanks.
We thank Vivian for continuing the debate for the affirmative side and invite Asher to continue the debate for the negative side. Hear, hear.
So first, I want to thank everyone involved for coming. I know the professors in particular are very busy, but I think this is a wonderful opportunity. I said this before, but I've learned a lot preparing for it, and I'm very grateful to be part of it. So I want to start by talking about what I agree with the affirmative team. And I think it's true that we're living in unprecedented times, that politics is moving faster than ever before, that our country is increasingly polarized due to either social media or perhaps genuine disagreements. And certainly we have a sitting president who's contesting the legitimacy of an election. I think that certainly raises the stakes for this debate. Where we disagree, though, is that I think the speed of politics and the polarization of the country actually makes a counter-majoritarian and a sort of slow-moving court even more important to preserving democratic institutions. And I think that's going to be the main theme of disagreement in this debate. So I want to talk about two broad themes in this speech. First, I'm going to talk about why the solutions proposed by the affirmative team are likely to be counterproductive, and this sort of weighs in on the tit-for-tat theme that we heard earlier. And then second, I want to talk about why it's okay and it's actually good to have a court in the long term, which is less beholden to immediate political interests. So first, let's talk about why the affirmative solutions are counterproductive. So I think Professor Henderson made the premise of this argument clear, which is that there are deep disagreements in the public and between politicians about what the court should do. So if Democrats, or really any party, makes a naked power grab in terms of expanding the court or radically reforming it, the other party, as soon as they get into power, is likely to do the exact same thing. What we heard from Vivian in response was that, I'm going to simplify the argument just a little bit here. It's sort of like a mutually assured destruction argument. It's that if both sides have shown the willingness to reshape the court, then both sides are less likely to do it because they know what the other side's that they're going to retaliate. I don't think this quite makes sense, though, because the reason that politicians actually reshape the court to begin with is because it locks their opponents out of power in general. So when Mitch McConnell refused to confirm Merrick Garland, this wasn't something he just thought he could get away with, that he was going to be unpopular, and if only Democrats had threatened to respond, he would have stopped. I think it was actually key to his strategy to continue to control the Senate. What this means is that there's no incentive for individual politicians, even if there's an incentive for the system as a whole, to not do this tit for tat, because it is precisely what keeps them in power, because it's popular with voters, and because when you actually take this action, it often makes you more popular, especially with your base, and that means that your opponents are less likely going to be able to retaliate. I do think Vivian also raised another point, which is that why is this back and forth, this tit for tat, worse than what we have in the status quo? And I think the affirmative has posited that we have an unbalanced court where conservatives simply have too much power. I think Professor Henderson already gave a very good explanation as to why this is the case, which is that the court fundamentally can't impose its will on this society because the court cannot enforce its own decisions. So if we go all the way back to Brown versus Board in the 1950s, the court manufactured a unanimous decision because they were terrified that the executive and the legislature would not enforce that exact decision. And what this means is that the court's opinions tend to track public opinion over time. In close cases, which are heavily politicized, the court cannot help but rule in such a way that the public finds broadly agreeable, because otherwise they know that these types of reforms that they are scared of are likely to enter the public consciousness, and debates like the ones we're having today are likely to become more prevalent. So I think even if the court is unbalanced in terms of who has appointed justices, I think what the affirmative hasn't proven that the court is unbalanced in terms of its decisions. So I think this back and forth, on the other hand, is likely to undermine the court's ability to make decisions and unify the country in types of things that actually matter, because it's seen as more political, it's seen as illegitimate, it's seen as just another type of political move as opposed to a genuine, bedrock of our democracy. I think that a case like Obergefell would have been much harder when people view the court as just, another tool for politicians to enforce their will, as opposed to something which is genuinely enforcing democratic principles. The second theme I want to talk about is why it's good to have a court which is less beholden to political interests. And I think Professor Henderson made these arguments pretty well, but I want to apply them specifically to the moment we're in, where I think, at least I personally am worried about the rise of authoritarianism and the decline of democracy in our country. And I say this both, of course, because Trump is contesting the legitimacy of the election, but also just because I'm worried that people on both sides of the aisle stop seeing each other's views as legitimate. And this sort of speaks to Professor Henderson's first point, that it's important that we have at least a couple of forums and something like the Supreme Court, which people see as above the political fray. So the key point here is that the Supreme Court can always be checked. And I've elaborated on this a little bit before, because the Supreme Court can't enforce its own decisions. But I think whatever types of reforms the affirmative is defending, whether it's expanding the court, whether it's term limits or reducing the length of terms, I think it's likely that it increases any politician's ability and any president's ability to make the court responsive to their own needs. I think this is crucial because it likely consolidates more and more power within the presidency and the legislature. What I mean is that if you have appointed more justices. And additionally, there's a norm that those justices are supposed to be beholden to you, that they're supposed to be involved in politics, as the affirmative has advocated for. I think it's more likely they're going to rule in favor of current incumbents. It means that the Supreme Court today would have been less likely to require that Trump disclose documents to state-level investigations in New York. I think this is bad because I think the point of the court, and the reason that it was introduced by the framers, or at the very least, one of the reasons that judicial review was introduced, was because it's supposed to prevent when the majority from in moments of passion, making mistakes that are ultimately bad for the democracy in the long run. And I think it's crucial to have even skewed justices who have been on the court for a very long time and are even perhaps potentially out of touch with the current political moment, defending our democratic institutions. I think even if they make suboptimal decisions in some respect, they're likely to protect our democratic institutions in the long run. And I think that is probably the most important thing we can ask of them. With that said, I'm very proud to oppose.
We'd like to thank Asher for continuing the debate from the negative side and his fine remarks. This is the part of the debate I think Mish and I are most excited about, which is we're about to open up the floor for a substantial period of audience questions. You can continue to ask questions in the Q&A function, and we'll continue to get for them. But we have a list that we've sort of compiled with the questions that have been asked so far, and we're excited to see some back and forth between the professors. We'd like to kick things off with the first question from Sarah Stresser about the professor's views on the following specific proposals. 1, increasing the size of the Supreme Court. 2, setting term limits as you see in Australia. And third, we have a similar question from Alice Hill about a retirement age for judges, not just for the Supreme Court, but throughout the entire federal judicial system. So we'd like to invite the professors to weigh in on those specific ideas.
So let me start. I should note that I am associated with a group that is been advocating for court expansion for a variety of reasons. I think that of the options that were on the table, expanding the number of justices on the Supreme Court is probably a good idea. As Professor Henderson said, it's not on the table at the moment. I'll come back to that in my concluding remarks. I just would note that the United States, so many people have thought about constitutional design around the world over the past 150 years. And as they've thought about it, there's virtual unanimity that a system that has a mandatory retirement age and or limited terms for judges, both on the ordinary courts and on the constitutional court, is probably a good idea. There are a lot of other variants that you could have, but it's the way I think of it is that there's been thoughtful consideration and experience with constitutional design over the past 150 years that is relevant to thinking about what a good constitutional design for the United States today would be. There have been, I think of it as innovations in the technology of constitutional design. And I'm reasonably confident that if we were starting now to design a system of checks and balances, we almost certainly would not choose life tenure life tenure in a constitutional court with no qualifications stated for even minimum age or whatever. The system we have in the United States is, I think it's true, exists here and perhaps in one or two other nations. It can't be that Canadians have just gone wildly off track in trying to design a constitutional court. Seems to me that, again, we should be open to considering the wisdom, not just of the experience of our country, but the experience of other countries as well.
So that's a great question. I'm hesitant to look to other countries' experiences and port them into the United States because there are so many other variables about our legal system that are completely different than they are in every other country. Who can sue, how lawyers are compensated, the entire legal systems are completely different. I stun my securities law students every year when I tell them you basically cannot sue in basically every other country in a securities fraud case the way we do in the United States. They don't have class actions. They're just innumerable differences in the way the legal systems operates. So while I am not one of these people who looks abroad and says like, oh, you know, we can't learn anything from the Dutch or the Japanese about our healthcare system, that's not my starting position. I think in terms of structure of law, those are very fraught comparisons. With respect to things like court packing, expanding the size of the court, I've written about this. I just firmly believe this is flatly unconstitutional. The court has only ever changed for reasons that had nothing to do with politics. There was one time when the Congress was really upset that Andrew Johnson was going to destroy Reconstruction, so they denied him Supreme Court justice seats. We learned that's a terrible path to go down. The only time the court's ever really gotten bigger is because of workload and practical considerations that had nothing to do with politics. Once we politicize the process of the size of the court, there is no end. The court, let's make it 435 people and have them come from all different parts of the country. Oh, that's what the House of Representatives is. The Supreme Court is supposed to be a different counter-majoritarian body. Vivian, in her remarks that I thought were excellent, talked about minoritarianism. Well, minorities need to be protected from majorities. That's the base fundamental principle in the United States. Let me just say one thing about term limits. I think there's two problems with term limits that have not been raised. The first one is, you know, the United States was a leader in rid of age discrimination. And I think the idea of setting a term limit for judges as they get older smacks of ageism. You know, Ruth Bader Ginsburg was doing amazing work up until the day she died on the court. And I think law is something that you get better at as you get older with wisdom and experience. And I think lopping that off at some arbitrary line is wrong. The last thing I'll say about the term limits is Republican appointed judges tend to get much more liberal over time. The trend is for almost all of them. I think maybe Justice Thomas is the one exception. And you risk, if you arbitrarily cut them off at 65, 70, that you will lose that sweet spot where they kind of mellow and become more liberal. So I think term limits is something that people on the left should probably think twice about.
Thank you so much for your responses, professors. And a quick reminder to the attendees that instead of raising hands, if you have a question, please do put in the Q&A. The next question is an anonymous question, which I will presume to be purposed to Professor Henderson. Democrats removed the filibuster for all except Supreme Court justices, and the tit-for-tat response by Republicans was to extend that approach to Supreme Court judges. How is it reasonable to believe that one side doing court packing or any other extreme step will not result in Republicans doing the same?
They will do the same. That's why you shouldn't do it. That's why you shouldn't do it. I mean, look, in the circles of people that I talk to about this, my friends who are pretty evenly split, lawyer friends, they will fight tooth and nail over who started it. They sound like my children. No, you started it. No, you started it. No, it was this. It was Garland. It was Estrada. It just devolves into, you know, just argument word salad. It's just a bunch of baba booey. And I think that this is a path we don't want to go down. And the reason that I'm confident, if it was the case that Trump installs 3 justices, they're going to be a bunch of right-wing hacks, which is, I think, the tenor of Vivian's remarks. They're just going to do their political bidding. Then I would be much more inclined to think that some reforms, maybe not radical reforms, but significant reforms would be justified. But that is, the data I cited from the work from my ascent is proof of that. If you look back in history at the justices that the Republicans have appointed, Stevens, Souter, Kennedy, the Chief Justice now becoming much more liberal and being the tie-breaking vote for the liberals, it's evidence that this idea that you put Republican appointed judges and they're going to be automatons that are just going to do the will it's not realistic. And as the questioner points out, the Republicans, if the Democrats pack the court or do term limits, they will seek their revenge. Now, Vivian raises a good point about game theory. Maybe 30, 40, 50 years in the future, they'll just get tired of this stupid game and they'll declare détente and there'll be peace. I don't think the risk is too significant between now and then.
Professor Tushnet, to extend this question to you, obviously, intuitionally, it does seem, or intuitively rather, it does seem that a tit-for-tat game is likely given the current climate. How do you perceive a forgiving tit-for-tat game, as Viv argued, playing out? Or do you see a scenario in which there is a more forbearing response from both sides? What is the threshold for you? Would love to hear your insight on that.
So I want to make 2 points. The first is a simple one. If the political conditions are such that court expansion can occur, and I put aside for the moment the constitutional objection that Professor Henderson raised, I'll come to that later, done by statute. The political conditions for that are democratic control of the House, the Senate, and the presidency. So once it happens, the retaliation can't occur until that configuration is flipped, until the Republicans attain the House, the Senate, and the presidency as well. And that'll take time. And lots of things can happen between the time court expansion occurs and the time the opportunity to retaliate arises. So in a condition of uncertainty, political uncertainty, it's not crazy to say, well, maybe things will change in a way that will turn the heat down on these kinds of things. The second point is that I understand the sort of schoolyard, you started at first discussion. I actually have published something about how those things occur. But from the point of view of essentially anybody, if you don't do something, then your opponents have, from your point of view, permanently gotten away with something. And it seems to me politically, you have to try to figure out some way to do something to respond to their, from your point of view, misconduct. Now, I'm not a politician, and I can't devise a strategy that would simultaneously offset the, again, from the politician's point of view, ill-gotten gains while not perpetuating the bad tit-for-tat kinds of responses. But I'm sure that politicians who are skilled at doing this kind of thing can come up with something. And so I would leave it to them to figure out what the right kind of response is.
Thank you, professors, for your responses. We have a question from Iris Brower. Do the professors consider the Senate's blocking of Democratic SCOTUS nominees and the subsequent reversal of policy to appoint justices under President Trump to be an example of a radical reform already occurring in the status quo? Does this not already invite the tit for tat that Professor Henderson argues that radical reform will lead to, or is it somehow distinct from that cycle? And there's another question here too about just sort of drawing the distinction between the tit for tat you might see in the status quo and the tit for tat that Professor Henderson envisions will happen in the world of the affirmative.
I'll go first, Mark, if that's okay. So I think I said in my remarks that I personally, and I'm not a politician either. We can all thank our personal gods that I'm not. If I were a politician, I think what they did to Merrick Garland was unreasonable. I thought President Obama was a colleague of mine. He chose somebody that was relatively moderate, fairly old. I thought these were signs of good faith that you're replacing this conservative lion, Scalia, and I'm going to do it in a way that is not replacing him with, the people who are on my progressive friends short list, Goodwin Liu or somebody like this that would be around forever. So I thought that should have been politically treated different. I'm not a politician. Okay, and this relates to the point that Professor Tushnet was making, which is the politicians have to do something. Let me say what they did to Garland was completely in bounds. We're talking about what the boundaries are here. That was totally in bounds. The Senate gets to vote on nominees. Whether they give them a hearing or not, Mitch McConnell said, we're not confirming your guy. And then they had an election and the Republicans won that election. That's what happened. The Senate was still in Republican hands. As President Obama said, elections have consequences. The boundaries and again, I think this is all dirty, and it's why I don't like politics. The boundaries, though, are we fight over nominees. If there's divided government and we decide not to give your guy a vote or vote him down, that's the way it goes. You didn't approve Bork, we're not going to approve Garland. That's what happens. And the Democrats can certainly, and I would completely support this, play hardball. If there's a future Republican president and the Democrats control the Senate and they reject the first 6 nominees that she sends up, great. That's the power that they're given under the Constitution. But to change the boundaries of the field, right? That's a dirty play on the field. To change the boundaries of the field just because you didn't like a dirty play that happened on it. No, win elections, fight back on those terms, and don't risk because once you change the boundaries, then it's like, oh, well, that's part of the game. Now we'll just change the boundaries in any way that suits us. That's what I'm against. Not getting revenge for Garland. The president-elect has talked about making him attorney general just to stick it in the eye of the Republicans. Great. That's a brilliant idea. When Biden sends up nominees, if the Democrats can control the Senate, they'll rush them right through. And if there's a future Republican president, they'll stick it in their eye. That I'm all in favor of.
So here a lot depends on the definition of what the bounds are. I'm perfectly willing to say that the bounds are set by the current Constitution. Just a footnote on that, of course, we do have a mechanism for changing what those bounds are by amending the Constitution. Okay, but if we're not going to do that, we don't have the political, ability to do that, then we have to know what the bounds of the Constitution are. And here, I just want to say that there, as with all or nearly all constitutional questions, it's not as clear cut as Professor Henderson makes it out to be, that expanding the court for reasons other than merely to change the outcomes of the cases is out of bounds. If you have some other reason, then maybe that's within bounds, okay? And I suggested that the reason is preserving or restoring the system of checks and balances, not to influence outcomes. Okay, so now we have to have a discussion of whether what I've just described fits in within his category of impermissible intent. Okay, I myself think that there's a decent constitutional argument for imposing term limits prospectively on court appointees. I find it very difficult to figure out how you can do it retrospectively, but and the proposal I've seen, I think, doesn't effectively do that. Tries to, but doesn't effectively do it. But so again, sure, you got to play within bounds, but we also need to discuss what the bounds are. And then there's just one final footnote here, which is over the course of the past years, 3 or 4 years, there's been a substantial discussion of, I don't know whether we could say it's been resolved, but a substantial discussion of the proposition that the bounds of our constitutional system are not set entirely by the written and interpreted provisions of the Constitution, that some of the bounds are norms of political behavior that have settled in for so long that, I guess in a Burkean sense, they ought to be regarded as within bounds. And then people start saying, it's not just we had dirty play within bounds, we had out of bounds behavior, which has to be responded to in order to ensure that the bounds that we have, that we thought we had, get reestablished.
Thank you so much, professors, for your responses to those questions. We have another anonymous question that I'm going to tie to a recent anonymous question directed to Professor Henderson. It seems that you're right that Republican appointed judges have historically drifted towards the center or even the left, but that trend has been a cause of great concern for Republicans. See, for example, the hand-wringing over Gorsuch's vote in Bostock. So my question is, why should we trust that Republicans will continue to appoint reasonably moderate judges? Why will they not simply vet their nominees more carefully so they remain stalwart conservatives over time? And that also addresses the final question we received. It's about whether or not this aligns with the Burkean ethic of protecting norms which have already been established.
Yeah, great question. So it is the case. So I love the question that says, like, the equilibrium you've described is unstable because the Republicans will get better at predicting how nominees will vote. And certainly that was the claim that was made, and Trump's very much ballyhooed nominees, now justices, went through this, depending on which side of the aisle you're on, either a well-oiled machine or a sinister Koch conspiracy network of things to get onto the court, and vetted, and they were the sort of golden children. And as the questioner suggests, Gorsuch, who was viewed as like a little mini Scalia, immediately betrays them, reaches in Bostock what I thought was the right answer, but immediately betrays them. Chief Justice Roberts, who was praised as this conservative lion, he's super religious and all these things, it's great background or whatever, and then immediately becomes the chief, and he recognizes, like, I'm running a political body here. I have got to trim my sails to public opinion. Otherwise, I risk the legitimacy of the court. And I think that's the thing that people are forgetting, is that this is not something that you can perfectly predict. Even Justice Kavanaugh, people think of Justice Kavanaugh as this pretty hardcore right-wing guy. He's a creature of Washington, D.C. I know him. I worked in the same law office that he did in Washington, D.C. He's a political creature. The idea that he's going to, even though he's personally opposed to abortion, join an opinion striking down all abortion laws around the country strikes me as completely implausible. So I think you're right. They will try to find the Justice Thomases out there, but by the very nature of the court, the Justice Thomases will always be the minority extreme version. There'll always be an extreme wing on right and left, Sotomayor and Thomas, and there'll be a huge area in the middle that is largely going to hew to what the political norms of the day are. And, if you'd ask Republicans, when Professor Tushnet started his sample in 1968, say, and if you said, Republicans are going to have, I don't remember the statistics, 75% of the justices appointed over the next 50 years. And then you would have said, abortion's going to be a constitutional right, gay marriage will be a thing, there'll be, and it just listed all of these things. They would have said no possible way. And yet that's the real world we're in.
Thank you, Professor, for your response. Oh, Professor Tushnet.
No, it's fine. It's fine.
Okay. Unfortunately, we only have time for one more question, and we'd like to thank the audience for just the caliber of questions that we've received in the Q&A chat. We think they're quite thoughtful and informative, and we're loving to hear the professor's responses on them. So we have a question about non-radical reform. To Professor Tushnet, in the context of Professor Henderson's argument, can you imagine any incremental or non-radical reforms substantial enough to keep the court on track And similarly to Professor Henderson, if you're drawing this distinction between non-radical and radical reforms, are there things that you could see as something that would address any problems that you could that you think sort of occur in the Supreme Court of the way it's politicized currently?
Okay, so I'll start with it. Okay, so I'll start with mine. One, this is sort of a joke, but I actually think about it seriously. The court has reduced its caseload by 50% while maintaining the same number of law clerks for each justice. A non-radical reform to make them do their own work would be to say, you've cut your caseload in half, we're going to cut your clerks in half. You have 2 rather than 4 now. Okay, so that I hesitate to say things this unequivocally. I would be very hard pressed to take seriously an argument that doing that was unconstitutional. Okay, that's the first point. Second point is less frivolous. If the Democrats are in a position to enact what I think of as ambitious reforms, there are ways of structuring, not eliminating, but structuring the process of judicial review that would simultaneously signal to the court that the political system is nervous about the way they've been exercising their power, and perhaps constrain the court's ability to overturn the legislation. There are ways of limiting the scope of review without eliminating it entirely. And more interestingly, with ambitious reforms, Democrats have gotten in the habit of writing general terms and saying, now you go figure out what to do with it. And now the court is responding by saying, well, that might be constitutionally impermissible, write more detailed statutes. So there are things that could be done that are that would not quite discipline the court, but reduce the scope of its ability to invoke the Constitution to counter the policy choices that emerge from the political process.
I love the idea of the clerks. That's brilliant. So I endorse that one. I saw in the Q&A that somebody said we could bring back the filibuster. I endorse that. That's a great idea. I think the idea of having 60 votes in the Senate to be a Supreme Court justice is a really good one. There was one of my colleagues in a just a work call, I don't think they'd written a paper about this, recently proposed a bipartisan commission to appoint Supreme Court justices. And as Professor Tushnet suggested, that would obviously require a constitutional amendment. So I'm against something radical like that. But the idea of having a group of people who would transparently propose nominees to the president, so the president would still have that ability to pick people, but Mark and colleagues from my school and politicians could develop lists, send those to the president, and try to make it the kind of social norm that Professor Tushnet talked about, that you're expected to pick someone from this list or something like that, that is part of the feeding process. So it's not done by the Federalist Society or the American Constitution Society sub rosa, but we bring that out. That would be something I would be in favor of, although that's not really a legal reform. I just want to note something that Professor Tushnet just mentioned, and I don't want to pick on what he said because it's not crazy. The idea of jurisdictional, it's not really jurisdiction stripping, but signaling something about Congress's displeasure. I just want to note that Pat Buchanan, who is a completely loathsome populist creature on the right, made proposals like this during the late 1980s, Republicans were very upset with the way the court had leaned to the left, even though it was a Republican majority court. And Republicans proposed jurisdiction stripping, or Congress gets a vote on Supreme Court opinions they don't like. So this idea that I'm upset with the court is something that comes around and goes around. And I feel like the Democrats, people on the left, are rightfully irritated at Merrick Garland. I completely understand that irritation, and I do think it needs to be salved. And so I'm completely open to salving it. But I think risking the structure of the court, which has been in place since the Civil War, to try to do that is too much of a step to take. And what I would just encourage the Democrats to do is let's try 5 or 6 things, including appointing Garland to be Attorney General, including sticking it to the next Republican. Let's try a few of those first. Let's try some of Professor Tushnet's, I think, suggestions for non-radical reform, and let's see what happens. And then if there's just a complete breakdown, if the Republican judges, as Vivian suggested, are standing athwart very popular Democrat passed legislation, then we'll talk about radical reform. I think we're just too early in the process to do that now.
Thank you so much to the audience for your litany of reflective questions and for the enlightening responses of both our professors. We are very sorry we're unable to answer every question, but this certainly testifies to the broad interest and indeed the salience of this topic. We're now going to finally transition to the 4-minute closing remarks from each side in inverse order. That is the negative, then the affirmative. I'm going to open the poll during these closing remarks. There are going to be 2 subsequent polls. The first one on whom you thought won this debate, and secondly, a distinct question on whether or not this changed your views going into the debate. So I'd like to welcome Professor Henderson back to the floor to start the closing remarks section.
You're here.
So this has been a total blast, and I'm not even going to look at the poll result because I'm a competitive guy, but I don't care. Because the main goal for this debate, from my perspective, was to engage in a respectful dialogue about an incredibly important topic with a bunch of smart people. And I met Asher, my partner in this, who's studying statistics, not even a policy person, and I don't know what the attendees are and their particular interests in this topic. But I think having this debate in the form that it was and the arguments that were mustered by both sides, I think everybody wins when we as Americans and whoever engages in this kind of thing. So that's the first thing I want to say. Look, I made my arguments at the beginning, so I'll just wrap up and say that the key words that I want people to take with them are independence and counter-majoritarianism. Both of those things are just deeply, deeply important concepts, and I don't want to lose them just because that people are really irritated about the way that politicians have behaved. The way to discipline politicians is to vote them out of office. 75 million people came to the ballot box and voted Donald Trump out of office because they didn't like the way he was behaving. That is how you respond. And I would encourage people who don't like the way that Merrick Garland was treated, go vote in Georgia, send money to people in Georgia, try to win those elections. That's where the action should be. I want to keep the court as free from political interference as possible. As Professor Tushnet said at the beginning, it's impossible not to have it be influenced by politics. We want it to be influenced by politics to some extent for the reasons that I've suggested, Maya Sen's research. But we want to try to keep it as insulated as humanly possible, because once it becomes a political branch, just another political branch, then the hard-won rights of minorities in this country, whether they're people who want to teach their kids their own language, people who want to have sexual relations with people that they want to, who want to marry people they want to all the things that we just cherish as freedoms, all of those things are at stake. Today's majority is tomorrow's minority. And people can get high on power and thinking, well, we're in charge today, we're going to do this, we'll always be in charge, we're going to get everything we want. I think that's a very, very dangerous game to play. So I'm against radical reform. I know Asher joins me, and I want to thank him at the end for his very excellent arguments in support of this position.
Thank you to Professor Henderson for closing the opposition side of the case and for his fine remarks throughout the debate. We'd like to invite Professor Tushnet for the final speech of the debate, closing the remarks for the proposition side. Hear, hear.
I just want to make 3 points. First, the opposition to the proposition talks about the system of checks and balances in a partial, that is incomplete way, because it didn't take into account the need in our system for mechanisms for checking the courts. So we do want independent courts, but we also want courts that are in some significant sense accountable. Now, what do we mean by accountability? Well, we want them to be accountable to law and not to phone calls from politicians, but we also want them to be accountable to the overall sweep of the political system. So in that sense, we do want them to be accountable to politics. And Professor Henderson's account of the drift to the left and his approval of that indicates that the opponents of this proposition also think that some degree of political accountability is appropriate. All that we are contending for is that in thinking about designing the court, modifying the court, that we take into account the need in a system of checks and balances to have checks on the courts. Second, I just want to emphasize something, that the case we put forward for court reform was focused primarily on process, not on outcome. That is, it may be the case that people on our side have been motivated to think about court reform by observing outcomes. But the argument that we're offering is not that we need to expand the court to make sure that it doesn't strike down Democratic sponsored legislation or whatever. The argument is that we need to expand the court or whatever in order to restore or to recreate the kind of system of checks and balances that worked well for most of US history. And then finally, a point that Professor Henderson made at the end of his initial remarks that didn't come up again, which is basically that it's not going to happen. At some level, I agree with that, but it's not going to happen immediately. But on the other hand, they'll go back 100 years to the era of progressivism. It took a decade or more for many of the progressive reforms to go from proposal, a little weird, but maybe we should think about it, to, hey, maybe we should take this seriously, to actually let's do it. And so, although 10 years from now, I'm going to be 85 years old and not care very much about this stuff, you people will have 10 years and more in which to deliberate about, think about, and argue over these kinds of propositions. And that's fine with me.
Thank you, Professor Tushnet, for your insightful conclusion to the affirmative case. All right, we'd like to thank everyone for what was a fantastic debate, a compelling inaugural installment to the Harvard College Debate Union's Public Debate Initiative. In particular, we would like to reiterate our thanks to Professor Tushnet and Professor Henderson for joining us, for letting us hear their thoughts on an issue we think, and obviously you do too, is of extreme public importance. And we're also very grateful for their willingness to speak to public questions on what can be quite a polemical and divisive issue. We just concluded our poll on whom you thought won the debate, quote unquote. We're now going to launch our final poll as we wrap up this debate on whether this altered your opinion on the matter. Thank you so much.
While you answer that poll, we'd also like to thank Vivian and Asher for joining us today and their thoughtful preparation and remarks. Lastly, we're extremely grateful for your support. We couldn't really have public debates without the public. In that vein, we'd like you to go show us some support on our Facebook page, Harvard College Public Debates. There you'll also find our email where you can send us topics you'd like to hear about or public experts you'd like us to solicit. Again, thank you so much for joining us. Have a great day, everyone. God bless. Happy Thanksgiving.